Our final panel is called Technology and Commercialization in Aging. There are two themes that have been, I think, present in the first three panels, but we'll hit them directly. And it's really important to hit their intersection because, as we've seen with many other technological developments, the commercialization aspect has a major impact on what the future will look like and therefore what the future of aging policy will look like as well. There are many themes you'll see in the papers today, but just one to mention is balancing the appropriate adoption of technology that is ready to go and could help in many spheres versus inappropriate, overpromise, and problematic adoption of technology, perhaps at the expense of safety, privacy, and health. So look for those themes. Save your questions for the end. And panelists, let's get going. Our first paper is called Redefining Competency, Legal Standards for Predictive Aging Technologies and Cognitive Decline, brought to us by Professor Mnotho Ngcobo, who's an assistant professor at the Louis D. Brandeis School of Law, University of Louisville. Congratulations, Professor, on finishing your first year of law teaching. He has experience in dispute resolution and mediation and health law, and was an ABA fellow where he focused on the role of technology in dispute resolution. So perfect for this conference. It's all yours.
Okay, thank you so much for giving me this opportunity to present today. I have been following the Petrie-Flom Center for the past 4 years, and I was excited when I got my abstracts accepted. So without going further, let me just say that the past panels, like the past three panels, they have talked about, how the laws, affect, the aging brain and the body. So now, in this presentation, what I'm trying to do is I decided to look at what AI technologies that we have right now and how they are used currently and how they can be used in the future in the cases of Alzheimer's, for example, in the cases of an aging brain. And what I found, and it has been mentioned before by the previous speakers, is that here in the US, if you look for example, in guardianship laws, you'll see that some of them, they differ from state to state. I know we have the Uniform Law Commission, and they have, but some of those laws are not adopted by all the states. So in this paper, what I decided to do then, instead of going through states to states, I decided to ground it in a constitutional framework, right? So maybe before I proceed, the question that I'm asking here is, can a person's legal agency be, curtailed not because they are incapacitated today, but because they are predicted to be incapacitated tomorrow? Because here, with these technologies, they are basically doing predictive, analysis. And we have seen in some studies, there's a study I read last week, actually, which I am going to include in the paper. We have seen that some of the scientists, they have actually used or tried one of the AI technologies to diagnose, a patient. So then, which then brings us to another question then. If you visit or if you take one of your friends, family members, or whoever, or your partner, to a physician for them to be tested, and then the physician uses one of these predictive technologies, and it finds that they have a 97% chance of deteriorating brain or aging brain. So, what is the implication of that? Can you use whatever prediction that you have received from the physician to now make a case in the court of law to be appointed, or to have someone be appointed as a guardian through guardianship, right? Or for another example, if they find that in 5 years' time, there is a 98% probability that the person will, their brain would have deteriorated to to an extent that they cannot no longer take care of themselves or of their affairs, financial properties, and all of that. Can you then also go and use whatever data or that you received from the physician? Can you then go to the court and apply for guardianship before, like 5 years before it even takes place, as a preemptive measure, for example? Right. So that's one of those are the questions I'm trying to answer in this paper here. Now, here in the USA, guardianship is seen as the last resort, right? The courts may only intervene when an adult has lost the capacity to make decisions in real time. And then the threshold is high by design, as we have seen in the Cruzen versus the director of Missouri Department of Health, whereby they made the justices, the courts had made a decision and rendered and argued to say the right to make decisions about one's body, health, and personal affairs is a fundamental liberty interest. That interest, while not explicitly enumerated, is rooted in substantive due process under the 14th Amendment. Now, here, this guardianship process, it serves as a constitutional gateway. And like all such processes, it is bound by due process. And also, if we can refer to the case of Eddington versus Texas, which requires clear and convincing evidence before an individual's liberty interest may be curtailed in civil commitment proceedings. And this standard applies with equal force in guardianship, where the consequences are similarly profound. Now, if we look at the predictive aging technologies, what do they bring to this question? So we have seen some scientists developing machine learning and AI technologies which have transformed Alzheimer's research. The models now, they integrate the multimodal data, including MRI, PET imaging, and so forth. And they also use information extracted from the electronic health records. And with these models now, the other problem that they raise is if we rely on AI to make these predictions, there's also the question of the missing data, which we always talk about. The AI might be trained on maybe, for example, on people living in affluent areas or white males living in affluent areas or, whatever. But there is always the missing data, which scientists have always been complaining about. So now, can we really trust any prediction made by such technologies? Right. And then, if we now look at this, how they disrupt, the Constitution, first, under the substantive due process, any restriction of autonomy must be narrowly tailored to a compelling state's interest. The state may assert an interest in protecting those at risk of harm, but that interest does not justify restricting rights on the basis of what might occur. So now, just to move forward, to make an example, through history. History warns us that the law has not always waited for harm before intervening. At times, it has punished not what people have done, but what they were feared to do, which we can also make the case here if we are going to be using predictive technologies to apply for guardianships. Now, for example, we can refer to the Korematsu, where the case where the Supreme Court upheld, the internment of over 120,000 Japanese Americans during World War II, not for actual disloyalty, but based on anticipated threats. We can also go to the Buck versus Bell case, where the court sanctioned forced sterilization on eugenic grounds, citing a presumption that Buck and her descendants would burden the state. One of the judges there wrote, chillingly, and I quote, "3 generations of imbeciles are enough," close quote. That judgment was rendered not only on present incapacity, but projected degeneracy. Now, if we also look at it now from predictive aging technologies, we cannot use them to make a case or an argument to say that a person must be placed on guardianship based on these predictive technologies alone. So, what is to be done. So I propose a constitutional evidentiary framework in which predictive tools may play a supportive but never a determinative role in guardianship. First, predictive scores must never serve as the sole basis of incapacity. They may justify enhanced assessments, but not guardianship without corroborated functional deficits. Secondly, functional evidence must remain the gold standard. Neuropsychological testing, clinician observation, and real-world indicators such as decision-making ability, financial judgment, and self-care capacity. And thirdly, guardianship orders must be narrowly tailored, temporally bounded, and subject to ongoing review. Predictive trajectories should inform oversight, not justify blanket removal of rights. I think I may be out of time, but I will close here. Thank you.
Thank you. Up to a great start. Our next paper is AI, Aging, and Health Insurance, Developing Age-Conscious AI Governance. And we have two co-authors on this. Barry Solaiman is Associate Dean for Academic Affairs and Assistant Professor of Law at Hamad bin Khalifa University in Qatar. He, in his work, creates new legal solutions to ethical problems posed by AI in healthcare, and of note, co-edited with Glenn Cohen recently, the research handbook on health, AI, and law. Check that out. Co-author is Abeer Malik, who recently received her LLM from Harvard Law School and was also a student fellow at Petrie-Flom Center, and her expertise is in regulation of AI-driven health, especially drug discovery. So thanks to both of you.
Okay, thank you so much for the kind introduction. I shall speak on behalf of Abeer and I, although it's very much a joint effort in putting this chapter together. So, just to give you some context so you can sort of visualize or conceptualize where this work is coming from, Glenn and I co-edited this book which came out last year. It's open access, and in it we identified several legal issues that come up time and again when it comes to AI in healthcare, regardless of the application. So medical liability, informed consent, intellectual property, data privacy, data security, data bias and discrimination. There are others, but in general, these six pose legal issues across the board. And so part of my research in the last couple of years has also been looking at how do those different legal issues manifest in different healthcare settings. And so in a paper that I wrote last year, I was looking at these issues in the post-acute and long-term care setting. And within that led me to the topic of this chapter, which is, and then Abeer came on board, which is to look at the use of AI in health insurance determinations for Medicare Advantage. So it was quite eye-opening in several ways, and I'll go through that. So I'll go through the institutional legal landscape surrounding Medicare Advantage, or MA, and the introduction to AI, financial incentives in AI integration, so how insurers are incentivized to adopt AI systems, how AI fits into prior authorization process, and then I'll go through the major legal and ethical challenges and how the courts are responding to this or might respond to this and what we should do about it. So this is premised on case law, which is yet to conclude. So this is still very much in flux, and the cases are still in the air, so to speak. So to give some context then, we're seeing AI systems play an increasing role in how care is delivered and paid for. Only recently have these cases started to test these developments, and they're testing it with regard to the application of MA plans. So what we first did then in this chapter was to look at, well, what is the environment in which AI is being deployed first? Let's take a step back. Before doing that deep dive into AI, what are the incentives that are at play here? And with prior authorization, that operates as a cost control tool. requiring healthcare providers to obtain approval from the private insurance provider before delivering certain services. The insurers are paid per enrollee, not per service, which incentivizes cost cutting. There's an incentive to overstate patient complexity so they can secure higher payouts while limiting actual care. The financial model encourages denying or shortening care, in essence, and doctors are paid less despite rising operational costs. So once we bring AI into this scene and prior authorization, AI tools have been used by insurers to determine what care gets approved. The prior authorization process therefore becomes opaque because we can't really know why AI is making these decisions. And these systems have been built to control costs within that greater structure that already exists. The incentive is already there, and AI helps take it to the logical conclusion. So instead of sort of clinical judgment determining what the coverage should be, algorithms are increasingly dictating coverage. So that brings us to the cases that we look at in the chapter. So the first two, they center around the same tool called NH-Predict, an AI tool. So in the case of Locken, the plaintiffs alleged that NH-Predict was used to deny MA coverage. It was overriding clinical judgment or recommendations, and this is all alleged, of course. We'll see how the case concludes, what the court decides, but the evidence that's been presented is that internal reviews demonstrated that denials were systematically flawed, and there was a 90% denial reversal rate of the actual cases that people bothered to appeal. So the really interesting thing about this, based on the scholarship that we've been building over the years, is that a lot of the examinations that have been undertaken in the literature have tended to focus on tort law or even regulatory mechanisms as a means to regulating the space. But why these cases really grabbed my attention was because of the emphasis on contract law. So the tort law claims and the statutory claims were preempted. Federal law takes precedence, so only the contract law claims could survive in these types of cases. And so what matters here is the promises from the insurers to those who are under the MA plans and what they're promising to them in terms of procedure. So it becomes a contract-based claim. And this is not something I've seen being anticipated that would become sort of an avenue for court cases for making determinations in this space. Similarly, we have in the second case of Humana, the same system used, NH-Predict. It was used by a different provider, and again, investigations confirmed that the algorithm prioritized expense reduction. Employees were even penalized at the insurer for authorizing longer care. Some allege that they were fired for authorizing care that was longer than what the AI algorithm recommended. So human oversight was often bypassed or even discouraged in this environment. So like Locke in the previous case, the legal strategy focuses on procedural breaches and a lack of transparency undermining potential fairness in this area. What are the contractual expectations and breaches of those contractual expectations, which again was quite similar to the case that went before it. A third case and final case, which also raised my eyebrows, was the case involving CVS, and this didn't come in from a contract law perspective, but from the perspective of investors and securities fraud. So investors of the insurer claimed that CVS misled markets about AI-driven cost savings. Apparently, CVS allegedly downplayed the role of AI in generating profits, but public disclosures tied billions in savings to algorithmic denials. So there was 2.5 billion in savings linked to denials, which is a massive portion of their profitability, which was driven by AI. So this is interesting because we're looking here now to a shift to investor impact. CVS is the first case to frame AI as a matter of investor risk in this space. The algorithm was central to cost-cutting and earnings performance, and executives were accused of hiding the legal risks. So here we've got algorithmic denial being tied to securities law breaches, wholly unique, and I haven't seen this anticipated at all in the literature. So we have then these breach of contract claims, which appear to be the main avenue that we are heading down. And so one of the sort of notes that we end on is, well, what is missing here? And is this really desirable? None of these cases considered age discrimination. There was no focus on civil rights claims in these cases. It was purely contract law, but surely these are important avenues too that we need to be examining for protecting residents or those that have Medicaid Advantage plans. Issues of AI bias aren't squarely addressed, which we have sort of outlined in our model in our book. And so basically, the civil rights law in this space hasn't caught up, and there has to be some sort of development in this area. So what we think in the interim, at least, is that courts must compel disclosure of algorithmic logic and use. AI can't lawfully replace nuanced medical judgment, especially in this space. Both courts and regulators have roles to play in closing these gaps. And we need legal tools that center on the specific vulnerability of populations, which these cases are an interesting development, but they haven't entered that space yet. So much to be determined, and I'll stop there. Thank you.
Great, thank you. Thanks to both. We have another a paper next that's going to look at some of the downsides potentially of health technology. It's called From Care to Technology-Facilitated Threats and Abuse, Legal and Regulatory Approaches to Safeguard Against AgeTech Misuse. And they're a trio of authors. I'll introduce all three. Diana Freed is Assistant Professor of Computer and Data Science at Brown University and also has been here a visiting researcher at the Petrie-Flom Center. A technologist, she develops new tools to detect and mitigate technology-enabled abuse. Malya Levin is Assistant Director and General Counsel of the Weinberg Center for Elder Justice. Attorney Levin represents victims of acute elder abuse and has published widely on the role of legal tools in elder abuse cases. And Tara Sklar is Faculty Director, Health Law and Policy Program at the University of Arizona James E. Rogers College of Law. Professor Sklar is an expert in telehealth and the law surrounding it, and her work examines broadly legal, ethical, and regulatory issues that arise as we integrate health technology with a diverse and aging population. A trio of all-stars, and I'll hand it over to you. We're all there. Your 10 minutes.
Great. Hi, everyone. So we're going to attempt to do this as a threesome. We'll see how this goes. But I just want to give my thanks and gratitude to the conference organizers. It's just been a truly wonderful day. I've learned so much. And I have to do an added thanks because of particularly Nina and Susanna, I got to meet my co-presenters today who conducted a study that you're going to hear about on technology-facilitated abuse against older adults. And where I was really brought in was to think about what legal protections, if any, could relate to their study findings. So over the next 9.5 minutes, we're going to start off with Malya introducing our vignette, our fictional character Elaine, who we think will hopefully really bring to this group like the very commonplace digital health tools that we're seeing older adults use. And then Diana's going to go into detail about like all the potential harms that could happen as a result of these tools, that while they may enable autonomy, they also could undermine it. And then we'll sort of conclude with, just the misalignment with like the current laws and organizational practices to really prevent some of these misuses in action. And because we've really enjoyed working together so much, we have a phase 2 part of the study lined up. But before I get too far ahead, we're just focused on this particular chapter. So I'll turn over to Malya to introduce Elaine.
Great. So in our chapter, we start by describing some of what we found in the study that we did, as well as in the work that we've all done, and we amalgamate that through the describing the story of a woman named Elaine. She's a 76-year-old woman, and in the first sort of era of her story, she's living independently, and she's using AgeTech tools, which are being used by her daughter to assist her in living independently. Those include she's using a smartphone that's tracking her medication, it's tracking her biometrics to ensure that she's healthy and doing well. She's using Bluetooth-enabled hearing aids, which help her hear, of course, but also have location tracking. She has a smart watch that's also, again, helping with monitoring her. And in this era, her ex-partner, as well as her adult daughter, are both exploiting these AgeTech devices to assert power and control over her. They are using the Bluetooth to track her location, know where she is at all times. They're using the smartwatch her ex-partner has set the smartwatch to automatically answer phone calls and video calls, so he can check in on her, see her, listen to her whenever he likes. And so together, all of these devices are helping her to remain independent, but they're also creating this bubble of sort of pervasive power and control that not only is she sort of powerless to stop, but she may not even be aware exists. And in the second era of Elaine, she moves into a care facility, and all this comes with her. There's no protocol for evaluating what's going on, and so again, all these things continue to occur. And some of them are being facilitated by the facility. They're continuing to utilize these AgeTech devices, and so this continues.
So just looking a little bit about this, there are two ways that we think about the technology-facilitated abuse in these contexts. What's happening with people that the person knows in their lives, so interpersonal violence, as well as when people enter facilities, the new technologies that might be introduced into their ecosystem, and looking at it in the terms of external violence. And so in this particular situation, looking at the types of attacks that different individuals experience when they enter into nursing facilities, the reason that these are happening is very similar to what we see in domestic violence and other types of technology-facilitated abuse, where the attacker, in this case for Elaine, it was an ex-partner or daughter, is somebody that has authenticated access to all the devices. They might own the devices, they might set up the devices, and so they're an authenticated user of the system, and there's really no detection mechanisms for that because most security systems are designed to really detect someone who's not an authenticated person using that system. And so there's a lot of exploitation. So looking at either phones or hearing aids, we're seeing different authenticated ways that people are using these. And then now we think about it in terms of what other devices might be introduced into Elaine's life or somebody entering a system. And when we think about a smartwatch, there's a lot of biometric data, and the problem that's happening here is that you really don't know at this point who has access to it. It could be the facility, it could be a company, it could be anybody taking care of this individual. Data is also going out into a system, and it's really not set up so that the person entering the facility who's wearing the device has a clear understanding of the data flows or has choices in terms of how to mitigate that. And there's no audits built into caregiving facilities that say we need to look at all the electronic devices on the person to determine what happens. And so we're going to look at a study that we did together to explore our research data. And so we did this study with Malya and I put together. We did it as a co-design study so that myself and Malya developed the study guide. We developed it's a mixed method study with surveys and interviews, and we spoke to advocates around the country and did focus groups and really had a very good interaction in terms of understanding what's happening.
We recruited people for the study through the Spring Alliance, which is a professional network of people who are operating or working to create elder abuse shelter programs around the country.
So basically here, what we're looking at is we wanted to find out in terms of like when people come in, as I said, there's no audits done. So when people come into facilities, right, are people looking at the devices? Are there any protocols to assess what's happening? And what we found is like, no, there's not really any type of assessment. So whether it's somebody coming in with abuse, somebody coming in with concerns, or any type of vulnerabilities, there's no assessment with devices. And also, what's happening on their social media? You know, should there be any concerns? So it's not that it should happen to everyone, but we should have these questions, should they be needed? Additionally, we said, you know, what kind of concerns do you have or are you seeing in the field around technology devices? And what was interesting is you see a lot of restrictions, people removing access or taking away assistive devices. And so how easy it is to do that in these types of vulnerabilities, yet we don't really have protections around them. And then we went into like, what was this person like before? How are they living in the world? Looking at the different platforms that they're at. And surprisingly, dating apps rose very high in terms of the vulnerabilities, which will probably give rise to a whole other area of research in this population, but it was interesting to see. It was a much broader use of technology than we thought. And also, you know, what are the concerns that older adults have? And a lot of it turned into not really understanding the technology or how to mitigate what was happening to them.
So, you know, we were thinking about the real world harms that these gaps in oversight reveal. People are experiencing, and you saw with Elaine, financial exploitation, but also emotional abuse, physical harm because of inappropriate or inadequate care. And we looked at some of the ways that the current legal frameworks really don't address this. One of the issues that I've experienced in my practice is in family law, and that in terms of seeking an order of protection, jurisdictionally, often clients can't qualify to receive a family court OP because the family offenses that they need to qualify for don't include any of the offenses involving computers. That's just a New York State statute. And so there's this big gap where someone like Elaine couldn't go into family court to get an order against these individuals.
Okay, great. And we're wrapping up with the yellow light, but we just basically, because this is a relatively new phenomenon, technology-facilitated abuse, the laws just lag behind. They aren't set up to address them. The closest we kind of came was the undue influence that I know that Duke was looking at as well with his paper. So what I think is an interesting trend is actually these consumer health data laws, and we talk about this quite a bit in the chapter. You know, there's now 4 states. Washington was the first with My Health, My Data. And then there's also Nevada, Connecticut, and New York is about to pass once the governor signs it. But I think it's a real opportunity here where just ways in which these companies could potentially just collect less data. And that would be a way where the onus isn't so much on the older adult or their family or these institutions to be sure to, you know, authenticate and track. There just would be less data in the first place that could be solely on the device of the person. And I think that there is a lot of interest. Anyway, it's in the chapter. But we have a lot of, we're going to keep working on this topic, and we really welcome your questions and any kind of feedback. Thank you.
All right, thanks to all. Our next paper is also a triumvirate of authors. It's called Menopause, Capitalism, and the Reinvention of Aging. I think 2 of the 3 authors are with us. I'll introduce all 3. Naomi Khan, who may also be online. Hi, Professor Khan, is the Justice Anthony M. Kennedy Distinguished Professor of Law, the Armistead M. Dobie Professor of Law, and co-director at the Family Law Center at the University of Virginia School of Law. Extensive work in multiple areas of law, including family law and with the Uniform Law Commission and the American Law Institute. Bridget Crawford is with us today as University Distinguished Professor of Law at the Elizabeth Hobbs School of Law, Pace University. Has written multiple books around feminist judgments, as well as 3 case books, and also featured in this wonderful compendium book called What the Best Law Teachers Do. So another fantastic law professor with us. And Emily Gold-Waldman is Professor of Law and Associate Dean for Faculty Development and Research at the Elizabeth Hobbs School of Law, Pace University. Published extensively in education law as well as on menopause and the law. And I'm sure you'll mention this, but a plug for the book. We're getting a snippet of a larger piece of work, the 2024 Stanford book called Hot Flash: how the law ignores menopause, and what we can do about it. So thanks for the book and for being here today.
Thanks so much for having us. I will get us started, and then I will pass it over to my colleague, Bridget Crawford, at the halfway mark. And so several people said to me at this conference, wow, like menopause is everywhere now, which is true. And we have been writing about menopause, the three of us together, since 2021. But new developments keep happening to make our discussion fresh. So why does it feel like menopause is everywhere right now? I think there are really 4 related and reinforcing developments that are happening. Number 1, there have been and continue to be new scientific understandings about menopause. So in particular, recently, there has been new neurological research trying to unpack the hormonal shifts of menopause and their impact on the brain, including through neuroimaging scans. Number 2, there have been new economic understandings about menopausal symptoms. So some of the things that the neurological data is showing in terms of hot flashes, trouble sleeping, sometimes brain fog. There have been new efforts to quantify that in monetary terms, in terms of women with menopausal symptoms leaving work, taking days off, reducing hours, et cetera. There was a recent Mayo Clinic study that evaluated the cost as $1.8 billion annually when you factor in all of the missed work. So new scientific understandings keep coming. New economic understandings keep coming. There also in recent years is more understanding about treatment for menopausal symptoms. In particular, after really what we call a series of hairpin turns around the safety of what's sometimes known as HRT, hormone replacement therapy, also referred to as menopausal hormone therapy, there seems to now be a new consensus that at least for many women, MHT can be safe and effective, especially when it's used sort of in the early period of menopausal symptoms. So we're seeing a greater awareness of symptoms, a greater understanding of the effect of those symptoms, and we're seeing more willingness to seek treatment for symptoms, again, depending on the individual. And then number 4, there is just discussion about menopause everywhere in popular culture now, perhaps because of those things, right? That it's become more widely known that menopausal symptoms are real, affect a lot of people, have impacts, there is treatment. There's just a lot more discussion about it. And you can see that in terms of public figures and celebrities talking about it, everyone from Michelle Obama, Drew Barrymore, in terms of memoirs, Naomi Watts, Brooke Shields, Maria Shriver, all writing memoirs either completely about menopause or at least in part. So there's just tremendous discussion, and you're seeing it in novels too, in movies, et cetera. So with all of that in the background, something happened a couple of months ago that was our jumping off point. I'm trying to go forward. Let me give this Okay, well, I'll start talking and then okay. So that was what we were gonna talk about, which was a little microcosm of what's been going on, which is on March 31st, Oprah Winfrey had the special, we said Menopause Grows Primetime. Her title for it was The Menopause Revolution. And it basically featured a mix of celebrities as well as medical professionals, but who have sort of gotten into the menopause space. So Dr. Mary Claire Haver, Dr. Rhonda Voxel, who is the faculty neurologist for the UCLA Comprehensive Menopause Care Program. And so you had this roundtable of celebrities, some of whom themselves now are also in the menopause commerce space, with doctors who themselves are also entering the menopause commerce space. And there was one particularly interesting thing that happened. So here were 2 of the celebrity menopause entrepreneurs, Naomi Watts and Halle Berry, both of whom have businesses selling products related to alleviating menopausal symptoms. But this was the thing that really caught attention, at least my ears pricked up, and so did many others. Dr. Rhonda Voxel said, as is the case with any neurodegenerative disease, as a neurologist, I can tell you it's very difficult to let things happen and to try to repair them. You've got to go in early, and perimenopause is a good point. And what she basically said was, at the time of your first hot flash, you should get medical attention. So this really was a little bit alarming to hear that hot flash can be analogized to the beginning of neurodegenerative disease, and it actually prompted some response, including by another sort of celebrity gynecologist, Dr. Jen Gunter, who on her blog pointed out that she thinks that's an overstatement, that menopausal hormone therapy isn't necessarily indicated for brain fog, neurodegenerative issues. And she also pointed out that Dr. Voxel, although she hadn't disclosed this, is herself a patent holder on a particular type of MHT, which again is okay. One of the things we talk about a lot is this blending of care and commerce, but it wasn't discussed in the program. And so one thing that we are really seeing with these new products is echoes of the past, and that's what you can see sort of on the left. An early version of MHT, Premarin, really became common in the 60s. It was surrounded by a lot of marketing about staying feminine forever. And we're seeing some of that shifting now into this idea of staying young forever, that a lot of this is being wrapped up in marketing around aging and perhaps staying forever young. And more broadly, I'll jump to Bridget's point, we're seeing the rise of what we call menopause capitalism, a menopause gold rush, as that indicates, with just tons of products developing. And I'm going to pass it over to Bridget to talk more about that.
All right, so we are super interested in menopause capitalism, and we define that as this burgeoning market for products and services about or for folks experiencing menopause that celebrate autonomy, community, femininity, and self-mastery, but for profit, and in ways for profit that are not always discernible to the consumer. Why? Because 1.2 billion people are expected to be postmenopausal by the year 2030. Emily alluded to this confluence of care and commerce. Are doctors selling themselves? Are they selling products? Are they selling advice? Are consumers asserting brand loyalty? Do the consumers think they are getting medically approved products? I myself was influenced into something called Sparkle Your Skin. So if you see me with a special glow, I can tell you all about it. We do talk a lot about this tension between empowering folks around this very important life stage versus selling products. We want there to be reduced stigma and shame about this inevitable stage of life for half of the population, and yet at the same time, many folks would like to keep that information private, particularly from employers, for example. We know that everyone's experience of menopause is different, and yet these apps and telehealth platforms promise that you can master your body by filling out an algorithmic survey and getting Sparkle Skin recommended for you too. Ultimately, we ask who benefits from menopause capitalism, and of course, it is not a binary. It is not profits against patients or patients in lieu of profits, but we ignore the profit piece at our peril. We will miss a host of legal issues unless we keep our eye on that profit. And we are going to let Naomi Kahn take every single hard question you ask. We are at time. Thanks so much.
All right, thank you to all. Our final paper of the day, it's hard to believe we're already here, it's been a great day, is Medicalizing Aging for Profit Through Medical, in quotes, Education. 3 authors. One here at the stand, but all in the audience today. So Lisa Vertinsky is professor of law at the University of Maryland Francis King Carey School of Law. Both an economist and a lawyer, is an expert on the regulation of healthcare markets and emerging medical technologies. Adrienne Frick-Berman is professor of pharmacology and physiology with a joint appointment in the Department of Family Medicine at Georgetown University Medical Center. She's the founder of Farmed Out at the Georgetown University Medical Center and a leading thinker on the influence of the pharmaceutical industry on physicians and physician decision-making. And then presenting is Caroline Renko, who's the associate director at Farmed Out, where she helps to lead Farmed Out's mission to advance evidence-based prescription and educating health professionals and students about pharmaceuticals and medical device marketing practices. We're looking forward to hearing the talk.
Excellent, thank you. Yes, so in our chapter, we wanted to highlight one of the most effective tools that industry, pharmaceutical industry, and commercial interests have in their toolbox to medicalize aging. That tool being continuing medical education, or CME. So before I dive a little bit deeper into CME itself, I want to explain a little bit what we mean when we talk about medicalizing aging, or the medicalization of aging, and how the industry does this. So this is the process where industry will repackage or redefine symptoms of aging that we consider normal aging and repackage them into medical illnesses or a disease that needs medical intervention or needs treatment. So something we used to describe as, yeah, that's just a part of aging, we all go through it. Now it's a disease. Now treatment is needed, a physician is needed. So how does CME fit into this? So continuing medical education, kind of like CLE, but somewhat different. Every physician who's going to see a patient has to partake in education after their official medical education training, right? So for Massachusetts, for example, if a physician is seeing patients, they have to take 50 hours of CME in order to keep practicing, in order to keep their license. So CME is very important for physicians to keep practicing. And the interesting thing is most of the education that physicians receive is in fact funded by the pharmaceutical industry, the industry that has products to sell, right? And the reason why it's very important when we're talking about aging is we go to physicians in order to understand what is normal and what is actually a disease, right? So if the education that physicians are getting are from the commercial interests, that poses somewhat of a problem there. And one of the interesting things, or really why CME is especially effective when it comes to medicalizing aging, is because it's not really regulated, right? So there is this body, the Accreditation Council on CME. However, ACCME for short, they rely on industry funding also in order to keep doing their job. So you have an accrediting body that relies on industry, and they're supposed to provide the oversight. It hasn't really worked out. Why this is a problem is if there is overpromotion, really overpromotion that comes from the industry, where the physicians are hearing this in the education, they're hearing that the drugs that the pharmaceutical companies have on the market, they're the best ones, that becomes a problem because overpromotion leads to overuse of whatever products that the company is promoting. And with overuse comes harm, and I will talk a little bit about that a little bit later on, but that's really the main problem that we end up seeing here. So what we then propose is that if industry-funded education, or really what we propose is if education is industry-funded, it's not really education at that point. It's now promotion. If pharmaceutical companies want to advertise to consumers, they have to go through a certain regulatory pathway where they have to go to the FDA and get a stamp of approval on their advertisements, right? There is a certain pathway that they have to follow. If they end up over-promoting their product, for example, or if they don't talk about the harms enough, they can get in trouble, legal trouble. However, with CME, there is no such regulatory pathway, and we propose that there should be. If industry is going to fund education, then it should be regulated as promotion. So in our paper, we dive a little bit deeper into some examples of how we've seen this medicalization of aging happening with CME. And it's great, we just had a wonderful talk about menopause, but in fact, menopause is one of the areas that we've also seen CME being used to educate physicians about some of the symptoms. So we were just hearing how there are a lot of products on the market right now, and the education that physicians have available on menopause right now and before as well is funded by people with commercial interests or the pharmaceutical industry themselves. So one of the things we've seen with menopause in the CME that physicians are receiving is there has been a big emphasis on what symptoms are considered to be menopause. So for example, with weight gain, right? There has been an understanding for a while that yes, as you age, sure, I'm not working out as much as I used to when I was younger. Of course, I'm gonna gain a few pounds. Okay, that's just a part of aging that we go through. Or some aches and joint pain that I think we usually associate with getting older. All of these things are now being combined and being said, oh, this is not normal. As you get older, gaining some weight or some of those joints and joint pains and aches that you're getting aren't actually normal. It's part of menopause, and don't you know, we have something for that. We can get you hormones for that. But the thing is, hormones don't really help with some of the symptoms that are being said to be a part of menopause, and physicians are being encouraged to prescribe hormones. So that becomes an issue, right? That's that overpromotion, which ends up causing harm. If someone doesn't really need hormones, then they should not be prescribed them. But that's not what physicians are hearing in the education, because who is funding it? People that have something to gain. We also saw it on the other end with men. Men, you're not safe either. Where with andropause or low T. So as men get older, their testosterone levels aren't as high as they were maybe when they were younger, and the levels differ as men get older. But there was a company that had a product on the market that decided we should teach physicians that low testosterone is not normal. It's not a good thing. It's a problem. It's a debilitating disease that men have been suffering with for a long time now. And physicians, what they did in CME, and what they do a lot of times, is this thing of disease awareness. So they won't necessarily talk about the drug itself, but they will hammer on this is a disease, this is a debilitating disease that people aren't paying attention to. So physicians were taught low testosterone is an issue. And of course, there was one product that was on the market that the company that was funding CME, that most of the physicians were learning, they were the ones who had a product on the market. So we've seen it on both ends. And these are just a couple of examples of the medicalization of aging and how CME has been used to do this. So one of the solutions that we propose in the paper, like I was explaining earlier, is that CME needs to be regulated. There needs to be some federal regulation, just as if a company is going to promote a drug to consumers, that should be the same for physicians as well. And we think the first step is to recognize industry funding in CME as promotion. The other thing that we also hear a lot of times when we talk about industry-funded CME is, okay, fine. If industry doesn't fund CME, who will, right? They're the ones who make the drugs. They should be the ones to teach physicians, right? That's one of the things that we usually get. Or if they don't foot the bill, who's going to do it? It's a lot of money that goes into educating physicians. One of the things we propose is states themselves can play a big role in this education, in this space. So I'll give an example of Washington, D.C. They're the only jurisdiction that provides free CME to their physicians. So what they did is, instead of relying on other entities, DC Department of Health created their own CME modules, and DC physicians could go and take it for free. And even other physicians from other states and other jurisdictions could also take it, but at a minimal fee. That way, if a state is producing its own evidence-based education, then that's one alternative instead of leaving it up to industry to do that. And we think other states could take that on as well, because if states are the ones who decide, physicians need to have licenses. This was a state thing that was put up where they put in bills to say physicians should be licensed. So we think states could also go a little bit further and provide that evidence-based education to physicians as well. And the thing about this is, when industry is funding CME, they are not promoting cheap generic drugs, right? They're going to be promoting innovative, supposedly, drugs that really cost a lot of money. And we think if states are to take up that education part, then there's a potential here of saving on the healthcare costs, because if we're providing non-biased, evidence-based education, then maybe someone is not walking out of a doctor's office with a prescription that they wouldn't have needed in the first place. So there is opportunities here for states to play a really big role in making sure that physicians receive good education and hopefully lessen the harm that may come to patients otherwise. Thank you.
Thank you. All right, so we've reached time for questions. You know the drill. If you'd like to ask a question, you can flip your card. Do you have an extra microphone? Okay, great. So we've got a microphone going around. I see things going up already. Let me first, although, give our panelists, of which we have many, an opportunity to ask each other questions, if you have them, and I have one I'd like to sneak in before we go to the audience. But panelists, do you have questions for each other? Yeah, go ahead.
Thank you. So the question is directed to the second speaker. You mentioned a couple of cases, and I was really interested in the CVS investor case. And one of the arguments that you made is that in these cases, they were based mostly on contracts, and the issues like age discrimination, gender, and so forth were never raised in these cases, right? Then my question is, could it be that the reason for that is the patients or the consumers, they do not have access to the algorithm? That's number one. And it's possible that they may never have access to such algorithm because the companies can easily claim trade secrets if they allow now everyone to have access to their algorithm. Thank you.
Yes. You've answered the question in the question, so you're spot on. Unless, Abeer, do you want to add anything? But yeah, so this is something we highlighted in the paper, and so one of the big questions is, at what point can courts compel the algorithm, release of the information of the algorithm, and it's protected by trade secrets. So it's an evolving area, but yes.
Other panelist questions? Let's stand up. One from over there? Yeah. Flip it to that little...
Okay, thank you. This is for the CME presentation at the end. I was just curious if you looked at medical schools. We provided a lot of CME at the medical school that I teach at, and I was thinking maybe in addition to states, if you're looking at more of a neutral territory, it might be another avenue.
Yeah, for sure. That's a really great point, and we have looked at CMEs from medical schools as well. And one of the interesting things too is industry funding comes in many different flavors. So one of the ways that we've also seen it in some medical schools or in those areas is speakers themselves who come to speak sometimes are in fact industry funded or are key opinion leaders that are funded by or paid by pharmaceutical industry. So it can get a little bit dicey, but medical schools are a really great place to do some of this work too. Yeah.
And just to add to that, actually, medical systems and medical CMEs are often funded by industry. And some of the medical schools have been actually the worst offenders in terms of putting out misinformation in industry-funded CME. It used to be that medical systems actually supported their CME offices. More often nowadays, CME offices are expected to fund themselves, and the way that they do that is through industry-funded CME.
And Professor Khan, if you just want to unmute, I think you should be able to talk and we'll hear you. We'll let you know if not.
Okay, great. Thanks so much. Can you hear me?
Yes, we can.
Okay. Thanks so much for drawing out the themes at the beginning of this panel. Another theme is, and I'm wondering how others think about this question of disclosure. how important is disclosure? I mean, we're talking about sort of the autonomy of the people who are being monitored. We're talking about the autonomy of people who are in the midst of this capitalism, the aging capitalism, menopausal capitalism. How important do others think disclosure might be in terms of a remedy as opposed to having governmental entities, for example, step in?
Great question. Anybody want to respond? Yeah, right behind you.
There's a lot of social psychology literature on this. It turns out that disclosure actually increases trust in the speaker. And I can tell you from many medical conferences that disclosure it definitely increases trust in the speaker, and at least in medical conferences, multiple conflicts of interest are seen as canceling each other out. If you have multiple relationships with companies, you're perceived as being objective.
Thank you. I'll ask one question, and then we'll go around the room. This came up specifically in the Menopause article, but I think broadly I've been thinking about it all day. Should we give serious consideration to the argument that many disagree with, but some agree with, that we should describe or classify aging as a disease? And there are pros and cons, but it seems that in many of the papers, if one did make that classification, it might have big effects one way or the other. So should we give at least consideration to that idea, that whether it's menopause or just more broadly aging as a disease?
I think it's an interesting question, and it's connected to a very related question, which is, should we think of aging or menopause as a disability? And the reason why it's a loaded question is, I think, the instinctive reaction is to think, no, it's not a disease, it's not a disability, it's like a natural part of the human existence, and we don't want to pathologize it. And in some way, doing so sort of could lead to more discrimination. And on the other hand, in some ways, the way our legal system is set up, the path to getting legal remedies is to classify something as a disability or a disease. So at least in the employment discrimination framework, the pathway to have an entitlement to workplace accommodations is that you have a disability that's covered under the ADA. And so it's really a double-edged sword that we have thought about in the context of menopause, right? That on the one hand, you don't want to think about it as a disability, and yet the legal system suggests that because we don't classify, quote unquote, normal menopause as a disability, that shuts the door to accommodations. So I think ideally the solution would be that you're not forced into that binary, that the legal system could instead think about accommodations not hinging on whether something is a disease or a disability.
Others have thoughts on that? Want to jump in?
If
Yeah.
I-
Yeah, go ahead, and then we'll go to the panel.
Oh, I was just going to say just what Emily said, but we've talked, and obviously this is from the disability community, the idea of universal design. But I think also, which would mean that aging would not be a disease, neither would youth, neither would middle adulthood, right? I mean, it's a question of that I think this entire, you've kind of summed up sort of one of the themes I think of this conference. Should we think of aging as a disease or as a normal stage of life? And as Emily said, it's a question of the experience of aging versus how the law approaches this. And so the question is, how do we reform the law to accept aging or being a child as a natural part of human existence?
Yeah, just a narrow thought about that, and this is really something that Diana's brought to my attention, but specifically with regard to our work around technology-facilitated abuse, a lot of the AgeTech devices that we spoke about, are not viewed as medical devices, and therefore the regulation that they're subject to is very different, and that can impact the degree to which the people using them may or may not be aware of their different functions and the way that they might be being utilized for good or for bad, in their lives, and the degree of power and control that someone could use them to exert, if they have sort of those designs. I don't know if that's an argument to view aging as a disease, but certainly the degree to which the medical field and age tech intersect is related to that question, I think.
Great. Let's go to Jessica, and then we'll start the rotate around. Do you want to jump in? Sorry, Laura.
This is for Caroline and her co-presenters. I'm just wondering if there's any research on whether insurance serves as a check on industry-sponsored medical treatment suggestions, or if that's useless since it's a computer making those decisions for learning, or people who are educated by industry education. But I just wonder if that's a factor at all.
I don't know much on the insurance end, but I might kick it off to my co-authors if there is something they can add there.
Is there anything you want to?
So if I have a drug and I say this is what you need to treat menopause, and I make a CME about it, and a doctor then prescribes this drug it's a sugar tablet, could insurance deny coverage because it's a sugar tablet? Like, could that be used as a check on this problem?
That's a really interesting suggestion. I mean, physicians can prescribe, anything for anything, right? But insurance companies don't necessarily have to cover it. So that's an interesting idea. Except for what?
Okay. So this just jumped in my head. I'm not sure it's useful, but you don't really need to say that aging or menopause is a disease or a disability in order to get accommodations, because we also accommodate religion. And maybe we could just, and religion is just something, most people have or many people have that sometimes requires accommodation. You can't work on the Sabbath or whatever. And I'm wondering if there is some kind of analogy to draw and just say, okay, menopause or aging is the same. Everybody has that, and sometimes it requires accommodation and sometimes it doesn't.
I'll respond. I have to say I've never thought about that, because I guess to me, if the two areas of employment discrimination where there's a reasonable accommodation requirement are religion, disability, and now, of course, pregnancy, I'm not sure that, are you saying that you think that could actually be a legal argument right now to a court to try to slot menopause or aging into the religion piece of Title VII, or just if we were sort of rethinking everything?
I mean, it's not a religion, believe me. But in order to not make it negative and say that it's a disease, you could say there are other areas of life that need accommodation, and now we recognize that this also needs accommodation, so not only diseases get accommodated, but other things get accommodated, so why not this?
I think it's interesting, and I think, in fact, the Pregnant Workers Fairness Act, right? The pregnancy is not necessarily a negative, and now there are independent requirements to make reasonable accommodations for pregnancy. So it's an interesting idea, and I think maybe, in theory, that could get built into the ADEA for aging, and then if you were going to cover menopause, a place to do it, if legislators were so inclined, would be maybe to broaden the Pregnant Workers Fairness Act, right? That it's not just about pregnancy, but about all sorts of reproduction-related conditions, not just pregnancy, but also menstruation, and then ultimately menopause.
And we do talk in the book some about accommodation, the idea of accommodation. But again, I think we go back to recommendations for universal design, which would make it so that accommodation would be less necessary. But In the short term, in the short term, we do figuring out how to fit the needs of someone experiencing menopause into current law is something that we have struggled with.
Let's go to Andy.
This question is for Barry and Abeer and possibly for Mnotho. It sort of horrifies me that someone would apply an AI model to determine whether someone's medical treatment, should be covered by insurance. And the reason it horrifies me is because of the inherent variability of those models. And so someone could easily be denied coverage based on a minor glitch or difference in the variables that are used in the model. I wonder if you could comment on whether it would be more prudent to use models to predict the risk of having to reimburse for the insurer, and therefore allow you to amortize your losses over time as an insurer. What am I trying to say? In order to spread the risk over many cases, so that as long as the model is good on average, the insurer comes out okay and the payer comes out okay.
I think here we have to look at sure, but I suppose it's all about motivation of these companies. And you speak about the variability, right, in the algorithm, but I don't really think that's an issue there. I think they're just systematically using this to deny coverage in a much greater way than they have done before. So there's not much variability in the sense that they're just trying to restrict coverage and pay out as little as possible for care. So how they use that, perhaps if they use it as a tool that gives a more accurate assessment of what a person's needs are for their care, that would be fair, as long as there is some appropriate human oversight of that. But what they're doing is the complete opposite of that, which is to restrict coverage as much as possible and tell their staff, if you disagree with the algorithm, you could be in some way sanctioned or fired. So yes, I agree with you, but I think the question is, how are these companies to be controlled in doing this or being allowed to do this?
Let's go to the next question. We got to keep moving. We've got about 10 minutes and 4 questions, so hi.
Hi. I had a question related to the commercialization of aging and menopause, and the first part of the question is just, do we have to rethink skepticism of these commercially funded studies at a time in which scientific grants more generally are being cut, and particularly related to women's health? Does that change the view of these more commercial studies? And then the second part is just generally, do medicalization and commercialization of aging have to move together? You might think it's good for something to be medicalized so you can talk to your doctor about it and they can bill insurance with a code that it's a disease, but maybe are more skeptical of certain pharmacological interventions. Thank you.
Naomi, do you want to take that one?
I have to, okay. I have to say, maybe it depends on the results of the studies. I do think, I was actually going to ask the final set of panelists to respond in terms of just because a physician has been involved in a study or has been employed by a particular company to do research, right? I think the question is, should we necessarily not trust the research? And you know, that goes. I take the points earlier about full disclosure that shouldn't necessarily increase trust, but it does show the motivation. And if we have peer-reviewed scientific journals that are carefully vetting the results in these studies, if there are data that can be replicated, and given current potential problems with funding these studies, including ongoing studies, one option, of course, is to turn to what's going on in other countries. But I think we might need to figure out how to better evaluate these industry studies. Again, I defer to the last set of panelists on what they think about this, and in terms of this question about medicalization and commercialization. I mean, medicalization itself is incredibly controversial. You can get treatment if something is medicalized. And that's, so again, we're in this world where there are paradoxes, where you need to recognize not just the two sides, but the complex sides of all of these issues.
So I just wanted to so medicalization is a concept, or it can be a negative or a positive. All it means is that you are taking some kind of phenomena and you are characterizing it in a way in which it requires sort of medical intervention or medical treatment. And so the concept has been around for a long time. Increasingly, one of the forces shaping the medicalization over time has been the pharmaceutical industry. And Peter Conrad has written a lot about that. He's a sociologist who's sort of followed medicalization over time. What we sort of look at in our paper is we do some detailed case studies to show the ways in which the reason that the pharmaceutical companies are needing to use CME to sort of to market and to market the drugs and to enlarge their markets is because we don't have those independent studies that are saying, right? In fact, oftentimes the marketing is to limit concern about some of the harms. We saw this also in the case of opioids, for example, and other cases where the marketing through education is used to say, well, don't worry about that. Really, you should just be focusing on some potential need. I think Adrienne had it.
Yes, we should not be trusting studies from industry, and it's already 70% of biomedical research is being funded by industry, and there are data showing that industry-funded studies exaggerate benefits, minimize harms, distort data, and that industry-funded researchers are more apt to do positive studies, of course. But it isn't just the studies. Medical literature in general is basically controlled by pharmaceutical companies. We have a lot of articles and information on that on our website. But I would just caution the menopause group. We've written quite a lot about menopause, and I've also been an expert witness in multi-district litigation regarding menopausal hormone therapy. So I've seen a lot of internal company documents, some of which I have written about. But the attacks on the Women's Health Initiative, the largest federally funded study of menopausal hormone therapy and the largest study of women in their 50s ever done in the history of the world on anything, those results have not been negated by any additional research that is going on, that has gone on. And when you hear negative information about that, that is coming from pharmaceutical companies. So it's not just products that are being pushed by pharmaceutical companies and these celebrities and these celebrity doctors. There's also bad science that is being pushed. The only symptoms that have been proven to be associated with menopause are hot flashes, vaginal dryness, possibly sleep problems, hard to separate those from hot flashes, et cetera. So I just would make a plea for trying to use more objective sources of data that are out there.
All right, so with 5 minutes left, what we're going to do, I'm going to sneak in one quick question. We'll take all the three, and we'll get to the final panelist. My question, Abeer, is for you. We haven't heard from you yet. You're an expert and a futurist here in law and AI and aging. And my question is whether you think it's the technology or the people using the AI that are really at issue here. And I'm particularly thinking of your paper and the individuals in the insurance companies who could look at the result and say, well, let's not use this. I think you've argued that they're like, yes, let's definitely use this. So is it the technology or the people or both? And then we'll work down the line.
I've always thought it's the people. I don't like blaming the technology that much. I understand it has its risks, but at the end of the day, it's the humans making the decision. Especially in this case, like Barry already mentioned, I think the problem here is people are actively trying to exploit the technology. They're using it to reduce their costs. So even though they can make the right decision, I don't think they are. So I don't know how much I would blame the technology for this.
Thank you.
I am quite pro-AI, usually. I understand the issues it has, but it again boils down to it's the people who've made those decisions.
Thank you. Okay, so we have Thaddeus, Richard, and Nina for questions. We'll see how much time we have for response and call it a day.
So Barry and Abeer, so I actually want to make the opposite point that Andy made. So I want to actually sort of defend AI. So first, 2 points. First, right, you're comparing it to human clinical judgment. And I guess what I've seen from litigation from Aetna, Cigna, United Healthcare is ain't so good, right? So I'm like, to what are you comparing the AI, right? The hypothetical ideal of what of a good and prudent exercise of clinical judgment, or what or the actual clinical judgment that's typically used by healthcare insurance companies. But the second point is you focused a lot on contract law, and I wonder whether it's state contract law or whether it's like a ERISA 502 claim. Is it possible that the insurance company could just promise in the first place, we're going to use AI, so it's not a breach of what they promised. That's all we promised to give you, was to run this through the algorithm. That's what we did. That's the result. So there's no breach of a promise.
Great questions, but we'll put the next ones on the table as well. Richard.
Actually, that was one of my questions for that group as well. In fact, in a prior life, pre-law school, I worked on corporate financial statements that were to the SEC, and it seemed to me one of the reactions would be in that CVS case, going forward, simply don't put a number on the idea of AI. You can just say you use AI. What got them in trouble was the $2.58 billion. That was the misrepresentation. So I guess what I draw from that, and the question for you to add to the paper, is if it is that easy for the next company to avoid this liability, is really contract law going to be the better approach? And picking up on Thaddeus's point, if all of the Medicare Advantage companies indicate that they use AI, then I'm not sure that they suffer any competitive disadvantage, and therefore they might as well just say it. It's not going to discriminate among prospective buyers. And finally, for Tara, Deanna and Malya, that was a very scary paper, and we had already had an hour and a half on suicide. But more importantly, for many older people who have chronic conditions, medication maintenance is critical. And so monitoring medication is not a disposable kind of thing. I would encourage in the paper to indicate what would be the solution, because this is a very, very valuable service that is being provided. Thank you.
Great comments and questions. Okay, Nina.
Question from Mnotho. I think you provided a fascinating thought experiment on whether you could constitutionally deny somebody decision-making capacity based on likelihood of future disability. But I'm querying whether it actually informs the guardianship analysis. After all, today it's not permissible to impose a guardianship based on future disability, even with a diagnosis of a progressive decline that we know is going to happen. And similarly, guardianship isn't in order unless there's also an unmet need. It's not just a capacity determination. So what I'm wondering is if you think there are other contexts in which these predictive tools might be used, and the type of constitutional pushback you're giving us might be useful.
These are great questions, but I'm looking at the clock, and so what I'm going to say is, why don't we have the answers to those questions just after, because I think Glenn is coming back on now, and you can stay up here, but we're going to wrap up the conference, but keep those questions, and we can talk right afterwards. And Susanna, let me turn it over to you. Well, first of all, let's thank our panelists. Let's do that. And there he is, Professor Cohen, and I'll turn it over to you and Susanna.
Glenn, let's put you first in line. We've missed you today, but we're glad to see your face.
Hopefully this works this time. It's great to see everybody. This has been an amazing day. The only thing that makes me more excited is that we're going to capture all of this in a great book that hopefully will be out to the world very soon. Thank you all for the amazing questions and presentations today.
Thank you. So on behalf of all of us at Petrie-Flom, thank you. This has been an amazing collection of thinkers and doers and scholars and a lot of Canadians and a lot of international perspectives. It's quite lovely to have. I want to let Francis and then Nina have sort of the last words of the day.
And can you remind us, Susanna, what comes next for all
Absolutely.
the authors? I know we've said it, but we could do that.
Absolutely, I appreciate the prompt, actually. So as we've mentioned to you, the final drafts aren't due immediately. You'll have time over the summer to work on them, and you will be assigned an editor to help you through that process. We have a good, robust system of how we get to publication. We, for the last 13 or more years, have put the final edited volume out into the world through a major academic press, so we're hopeful that that will happen again, but regardless, we're committed to publishing something with all of your thoughts in it, and we look forward to the fine-tuning process, because I think today gave us all a lot to think about.
Yeah, I just want to say thank you to everyone, to my co-organizers. It's been a ton of fun. Days like this are when it's really fun to be a professor, and thanks to all the panelists today and all of you. Just three quick things. One is that you'll definitely hear from us, and we look forward to working with you on our individual basis. Secondly, it was really cool to see such interdisciplinary collaboration, new ones, old ones, medium ones, and as you write, that will be one challenge, is you're not writing for your little part of the academic world, you're writing for those of us who might not understand it. And the third thing is just, it's going to be really interesting to see where all of this goes, and I'm glad that so many of you are doing really applied work. That's one thing that really struck me today. Sometimes these conferences are so theoretical and awesome, but so theoretical, and this was so applied in really important ways. So thanks for all the work you're doing.
I'll just reiterate the thanks and say, I think this is the beginning of a small community here. And so you will get feedback from whoever is assigned your editor, but I'd also encourage everyone here to see themselves as part of one project. And if you have ideas that maybe you didn't get to articulate here today, but they might be helpful to an author, please reach out to that author. And likewise, if you heard a question here and you want to dig deeper into it, please reach out to the person who provided that. And of course, we can go back to the live stream as well if you're wondering what was that was asked. So I see this as a start, not a finish, and I'm just so delighted that you all participated.
Thank you. We will be posting the live stream recording in the next couple of weeks. We will be in touch in that same time frame with all of our authors. Thank you again. Safe travels, and thanks for being here.